Welcome to today's program titled Business Immigration Developments and Their Implications on Employers. At this time, all participants are in a listen-only mode. For those of you who are logged into the web presentation, you are encouraged to submit questions throughout the conference by typing them into the Q&A box on the right-hand side of your screen. For those interested in obtaining CLE credit for this webinar, an attendance verification code will be read during the presentation that will be required on the CLE attendance affirmation form. Please write this code down as it will not be reread and is required for CLE credit. Copies of the webinar recording and materials will be distributed to attendees in the days following the webinar, and you can find the CLE attendance form attached to the connection details email you received this morning. On the next slide, you will see a legal disclaimer. This presentation has been prepared by Seyfarth Shaw LLP for informational purposes only. The material discussed during this webinar should not be construed as legal advice or a legal opinion on any specific facts or circumstances. The content is intended for general information purposes only, and you are urged to consult a lawyer concerning your own situation and any specific legal questions you may have. At this time, I would like to turn it over to our first speaker for today's program, Leon Rodriguez. Leon, please go ahead.
Good morning and good afternoon. If you have joined us for this webinar this afternoon, it is because either you know or you have reason to suspect that this has been a time of significant developments and changes in the world of employment-based immigration, particularly in the areas of both the H-1B and PERM categories. And so, as we have been as immigration lawyers working through these changes, we realized that now would be a very good opportunity to give you all an overview of these changes, how they affect you as a practical matter, and hopefully leave a little bit of time for questions toward the end in order to field your questions. And do feel free to put those questions into the chat box as we go along. Again, my name is Leon Rodriguez. I'm a partner in Seyfarth's Washington, D.C. office, a part of our business immigration group. Before I joined Seyfarth, I was the director of U.S. Citizenship and Immigration Services under President Obama. I am joined today by two absolutely top-notch business immigration lawyers. Many of you have probably already seen Masa Aliascari, one of our partners in Los Angeles. Masa is the lead partner on a number of our most significant and complex business immigration accounts. And she's been doing this for a while, as I think you will see when you hear her remarks today. In joining our webinar world, I think maybe for the first time, is Shelley Song, Senior Counsel in our LA office. She's one to watch. I think you're going to be seeing her here more than just today. And she also has been working in both the business and family-based immigration spheres for a long time. And like Masa, she has responsibility for a number of our more significant accounts. So both of them really live these developments day to day, and will be able to share not just the technical legal aspects of those developments, but really what they mean for you as you perform the various HR, in-house legal, and leadership roles that many of you are responsibilities that many of you on this call have. So let me give you a quick overview of our program. I'm going to walk you through recent USCIS updates, perhaps a little bit about what's also going on at the State Department. And then I'm going to be turning over to Shelley and then Masa to take you on a deeper dive regarding a number of those developments. So let's talk about those recent USCIS update. What's been going on at my old agency? Let's see what we got on that first slide there. So we are at March 21st. So for those of you who are affected by this, you know that the new H-1B cap rule is in effect for this registration cycle. This switches from a regime where the lottery selection would focus on the individual petition rather than the individual beneficiary. We moved basically from a petition-centric cap selection process to a beneficiary-centric cap selection process. And that means that in this first round, a beneficiary can only be selected once and for one position, as opposed to before where beneficiaries were perhaps being selected multiple times. And this will prevent some of the fraud that was likely adversely affecting a number of you in last registration cycle. We now have electronic H-1B filings. And now moving away from USCIS and DHS for just a second, the domestic H-1B visa renewal program began on January 29, 2024. It's going to extend just a couple of more weeks until April 1, 2024. It is a pilot. I was asking around to my colleagues and asking them, how many of these have people had? And we handled thousands of these. And I was hearing only about a handful, which means that only a very limited number of people have actually been able to take advantage of this visa renewal pilot. It permits people to avoid having to go overseas to renew their H-1B and instead be able to do it here in the US. It was limited to individuals from either Canada or India during this narrow window of time. We are hopeful, however, that, and I think there is significant interest on the part of the State Department in making that happen, certainly from the interactions I've had with them, that this will become a more permanent fixture in our immigration system.
Leon, if I may just add a couple of really quick things, just logistically, I know a lot of clients were interested and excited to hear about this concept of electronic filings. Finally, the USCIS is coming into this century, but they're coming into this century a little bit slow and a little bit behind times in terms of what's really happening on the ground with clients and their counsel. It is a very limited functionality in terms of this electronic concept of filing an H-1B beginning April 1. We were excited about it too. I don't want to sign my name anymore. It's enough. But the way that they've set it up, it doesn't account for the fact that there's multiple attorneys working on with clients. There's multiple paralegals. There's multiple signatories across the board. It also doesn't account for the fact that documents are prepared far in advance. They're not prepared that day and submitted that day. There's rounds of review and authorization that takes place before something actually gets sent to USCIS. There's no ability to feed into the USCIS system from our own systems, for example, right? So in this first instance, I think most large companies that are working with counsel will probably not be able to really leverage this electronic filing yet. Hopefully, USCIS will start to take some measures and take the feedback that a lot of us have been providing them on what is more reasonable and feasible for us to be able to use it, so that we can start using it. But in the sense of an emergency, we all come across those. It could be helpful and useful and definitely leveraged for that. But we were a little bit tempered once we saw what they actually had to offer in terms of, how great of a leap forward this is or is not. And the domestic visa renewal program, we were all excited to see it back. For those of you who've been doing this long enough, way back when, before 9/11, we used to do this regularly. It was visa revalidation. It was a fantastic program. So we're definitely all very excited to see it come back, but definitely not as publicized, or if it was publicized, not as used by individuals. So hopefully the pilot program will extend and we'll be able to see an increase in that use of it, so people are not worried about being stuck abroad. for something like administrative processing.
Let's move on to the next slide. So there have been a number of changes in terms of immigration fees. Premium processing fees were raised on February 26th. They're now up to $28.05 for premium processing on most both non-immigrant and immigrant visa petitions. Additionally, on April 1st, the adjudication period for premium processing will change from calendar days to business days, which will functionally lengthen the amount of time that USCIS will allow itself to meet the premium processing target. On a broader scale, there is a new fee rule which will be effective on April 1st. It has a number of new features. There will be separate I-129 filing fees for H-1Bs, L-1s, other non-immigrant case types. Those fees are also going up. There is now, for the first time, an asylum program fee, also characterized as an asylum surcharge, in order to fund and to address the ever-growing backlog in the asylum system. These fees will be imposed on employment-based visa petitions under forms I-129 and I-140, in other words, both the non-immigrant and immigrant petitions. Additionally, in the case of green cards, separate employment authorization document and advanced parole fees will be required. Yesterday, actually, Tuesday, a lawsuit was filed challenging the fee rule in its entirety. Some of you may remember back in 2020, the Trump administration filed a fee rule which was very quickly, one, legally challenged and then ultimately enjoined in federal district court. It never ended up actually being implemented. In this case, the lawsuit raised both some new challenges and also very similar challenges to those raised against the Trump rule, basically arguing, one, that the accounting methodology was not adequately disclosed in the filing in order to justify the fee increases, and that, two, that accounting methodology was, whatever it was inadequate to support the rule as presented. There has not been what is called a temporary restraining order filed, which means there's a pretty decent chance that, notwithstanding this lawsuit and notwithstanding what the court ultimately does, that this fee rule will go into effect on April 1st, that it will not be stopped between March 21st, which is today, and April 1st. If it is stopped, it'll be stopped at some later time after April 1st. So that's going to be something to watch, because it is going to significantly affect, especially for those of you having to manage large volumes of payments for immigration filings. You could be experiencing some back and forth of a period of time where you're going to be subject to the new rule, but if there is some sort of court-ordered injunction stopping the further implementation of the new rule, you could find yourself reverting back to the old rule. So that is something that you'll be wanting to watch carefully over the coming, at least the coming couple of months. And finally, there has been a recent rule issued by USCIS extending the employment authorization document validity period to 5 years for a number of categories, including, importantly, for those issues based on a pending adjustment of status or I-485 application. And so with that, we will now dig in more deeply into the H-1B modernization rule. I will say before I turn it over to Shelley to discuss that, I will note that notwithstanding the fact that the rule was first issued as a notice of proposed rulemaking back in the fall, only the registration aspects of the rule have now been made into a final rule, and there is no clear timeline for when that rule will be implemented. There were a number of comments made expressing significant concerns and frustrations with key parts of the rule, and it is not yet clear. It's not generally. It's hard to know what they're thinking inside USCIS. But it's reasonable to think that they are figuring out, one, how to address those comments and potentially whether they can move forward with the rule as drafted in light of those comments. And so with that, I'll turn it over to Shelley to take us into one of the key provisions of that proposed rule.
Thanks so much, Leon. So like Leon mentioned, DHS and USCIS did propose an H-1B modernization rule late last year, and there were several provisions in the rule that a lot of people did take issue with, and I know we had a webinar on it previously that went into more detail. Today I'm just going to speak about some of the provisions or the proposed rules that might impact you as an employer. And like Leon mentioned, a lot of people did submit comments in regards to the rule and portions of the rule. I think at one point it was 1,300 comments or more were submitted on various aspects of the rule and how it might impact the business community. You can move on to the next slide. So one of the main provisions that might become an issue is the redefinition of what specialty occupation is. So specialty occupation is required for an H-1B visa to be issued, and that means that the position requires at least a bachelor's degree or higher in a field that's specific or related to the job that is being sponsored. And the issue was whether general degrees, such as degrees in business administration or liberal arts, could be required for a job, and whether that job could then be a specialty occupation or categorized as a specialty occupation. Now, usually people don't get like liberal arts degrees. They'll get a degree in maybe humanities, and then there are business administration degrees that are issued. And so without further specialization or concentration, USCIS could determine that those degrees, if they're required for a job, would indicate that the job itself is not a specialty occupation. I would say that the biggest impact that we foresee is on certain fields like consulting or finance industry jobs, where they commonly employ people who do get MBA degrees, and in those degree programs, schools don't necessarily always identify a specific major or concentration, and those degrees themselves do arguably provide individuals with a tailored set of skills that would indicate that it is a specialty occupation. So our firm did submit, our immigration group actually did submit a comment in regards to the definition of specialty occupation that USCIS is putting forth in the modernization rule, basically arguing that these quote unquote general degrees are not necessarily general degrees and actually do teach individuals very specific skill sets and knowledge that are needed for certain jobs. Now, what can employers do to kind of address that proposed rule in the fact that it does go into, that it does become law and gets implemented? they can, for employers who do allow general degrees like business administration or general engineering, it may be beneficial to start specifying certain concentrations that you need for that job that are related to the role. So for example, if you need somebody who has an analytics background, but they have an MBA, so it might be something to specify in the job description in the event that you need to sponsor that position for an H-1B. The same goes for engineering. Engineering is a pretty wide field, and so there may be specific types of engineering that are more related to the role, and so it may be beneficial to start specifying that in job descriptions. In addition, academic institutions, specifically for like MBA programs, may want to consider moving forward with identifying specific majors or specializations for their program if they don't already, and indicating those on transcripts if someone is enrolled in those specializations, because it may be become an issue later on if this rule does go into effect. I do want to say, though, that the implementation of the rule, if it does go into effect, it may vary based on the administration that's in charge at the time, because we did see this crackdown on the definition of specialty occupation during the Trump administration, where there were a lot more requests for evidence issued on H-1B petitions specifically related to individuals who had MBAs or positions that required just general engineering without specifying specific types of engineering that might be related to the role.
Great. And then the other big component of this rule is what is commonly called the third-party placement issue, which we'll see on the next slide. This is really codifying what has been the view of USCIS for many years. It applied in different ways at different times, but basically seeking to treat those who are petitioned for by one company, but are functionally staff of a client of the petitioning company, to make clear that the requirements of the company where that individual be placed are the ones that really govern both the qualification of the individual for the role and also the qualification of the position for the role, rather than those of the petitioning employer. And so this is now being codified in the regulation. USCIS has strived to make clear to distinguish between a beneficiary who is staffed to the third-party company versus one who provides services to that party. Whether they've been successful in that, I think, has been a question of concern among many commenters, both from the perspective of those staffing services for whom this will impose significantly greater burdens in defining the specifics of what an individual will be doing at their client company, and also from the perspective of client companies adding new paperwork burdens potentially to support their staffing vendors' applications. And so this is one of those areas where it's unclear how exactly USCIS will ultimately thread the needle in order to not catch within the net of these changes individuals who really are functionally providing services to a third party but are not really parts of that third party workforce. One very positive development is that this aspect of the rule does, for once and for all, do away with an itinerary requirement when filing petitions in these cases. The rationale that USCIS has offered for doing so is that much of that content is already present in both the labor certification filings and in the initial I-129 petition. And therefore, it really obviates the need to have that as part of the initial filing for those individuals. Again, I believe this is, from what I have seen, this is both this and the area that Shelley discussed have been the subject of extensive commentary. These are areas of great concern, both for sponsoring employers and for legal counsel working with those employers. And we hope there will be some movement in this area, but it's still unclear exactly where USCIS will land on these issues.
I'm curious, Leon, your thoughts on kind of the additional wrinkle of potential issues from an L&E perspective of this additional requirement creating more of a joint employer liability red flag for employers, because I know right today, if a client comes to me and tells me this vendor is asking me to sign on this letter that they're going to submit to USCIS about the requirements for the position, my answer is no, don't. They're not your employee. You don't dictate their requirements or their job duties, because the minute that you do, then I'm concerned about what that says about your obligations as a joint employer. And this would really kind of front and center put that right there. Any thoughts about that?
Yeah, no, I mean, as somebody who, depending on the day, has been characterized as a litigator who moonlights as an immigration lawyer, an immigration lawyer who moonlights as a litigator, I know that this is, something that if I were on either side of just a traditional employment case, either a wage and hour issue or something along those lines, one of the things I might look to from a discovery perspective is exactly that. What is the actual level of control that the client company has? I would look for evidence that that client company is in fact functionally the employer. And one of the things I might look at is, did you provide information in support of this individual's petition? And doesn't that mean that, the way you said it, Masa, that individual, that it's in fact the client company who is defining the role of that individual rather than their nominal employer? So yeah, that is a pretty significant concern that arises from that.
Yeah, and I think as companies utilizing the H-1B program, whether you are the vendor, the contractor, the staffing firm, or the recipient of that, you really have to be careful. There's a reason the statements of work are set up the way they are. There's a reason the terms of the agreements between the two parties are set up that they are. There's a lot behind that that's not specific to immigration. And this really adds that layer. So in the next iteration of this regulation, wherever they end up, provided there's more room for note and comment or litigation, I think it is important for all of us to be paying attention to that and maybe taking a stronger stance on these types of things, because it bleeds into other areas that I think create more liability for companies who are trying to use the visa programs to meet the needs of the business.
Yep, wise counsel indeed. And since you have the floor, Mas, I think you get to say the CLE code.
Yes, I do. So for those of you needing the CLE code, it's SS1741. So S as in Seyfarth, S as in Seyfarth, 1741.
Okay. And now we're going to move away from the regulatory sphere and the changes in the regulatory sphere, and now really dig into some important enforcement issues in really the non-discrimination realm that have the potential to significantly impact, above all, perms, and Masa is going to talk to you about those, but is also the H-1B non-immigrant filings as well. So Masa, I'll leave it in your hands to tee this one up.
Yeah, great. Thank you. So as we'll see on this next slide, this is kind of the theme here from what we just mentioned. there's other agencies involved. There's other impacts that what we're doing in immigration and how you're using various immigration programs are now being looked at by different agencies for different purposes. So in the context of PERM, there have been very high profile settlement agreements that those who are in this space, those who use the PERM program, especially at a high volume, are really paying attention to. And the biggest thing that sticks out, I think, right now is the Department of Justice and how they've been involved in these two high-profile settlements that have taken place in the last couple of years. And what does it mean for us as we move forward in utilizing this PERM program to meet the talent needs of the organizations? So in these two high-profile cases, one that took place in 2021 and then the most recent one in 2023, similar stories in that they all related to this PERM program. For those of you who may not be aware, the PERM program is one that is related to immigrant visa sponsorship. And so individuals who are in H-1B status, in TN status, and in a myriad of other visa categories are here temporarily. So if a company wants them here on a permanent basis, the PERM program is one of the most widely used and available options to pursue a green card for individuals. And what it involves is a test of the US labor market that has to take place first. So the Department of Labor is involved in this because they're the ones who are certifying that you've completed this test of the labor market and that you have this need and that you may move forward with this sponsorship. So that's the Department of Labor. So you would expect this slide to refer to the DOL, but it's referring to the DOJ. And why is it referring to the DOJ? Is because at its core, it relates to the INS, the Immigration and Nationality Act's anti-discrimination provisions. So the complaints that arise out of how companies use the PERM program and how they test the labor market have made their way into the Department of Justice because of the INA anti-discrimination provisions. And as you can see, this isn't a couple $100. This isn't just, a small claim that you're defending. In these two settlements, they were landmark decisions. They were landmark settlements, with the 2021 decision resulting in $14.25 million of monetary award, which at the time was the highest ever awarded. That was supplanted by the 2023 settlement for similar issues related to the PERM and how companies are conducting the test of the labor market. And that topped it at $25 million. The other interesting part is that the investigations that took place kind of overlap the timeline for both of these settlements. While one took longer for the settlement to come through, the first case involved an investigation that took place from January 2018 through September of 2019. And that was the one that resulted in the settlement agreement in 2021. The second one started in 2019 and finished up and wrapped up in 2019. So really at its core, it's about employment discrimination, and that's why the Department of Justice is involved. Why the Department of Labor's kind of scope is to protect U.S. workers, to ensure fairness, to ensure that the foreign workforces are not used to take away jobs from the U.S. workforce. The Department of Justice has a different mandate, and it really is just underlying the employment discrimination claims and concerns under the INA. And the target specifically on these two investigations and ultimate settlements related to the recruitment practices in the context of PERM. So what was really highlighted in both of these scenarios was the way that the two companies conducted the required recruitment for the test of the labor market under the PERM program. By the letter of the law, they followed it. They follow the Department of Labor regulations that are specific to the PERM program. But the question was, ultimately, from the DOJ perspective, why was it different, right? What is your standard recruitment practice compared to your PERM recruitment practice? Is your PERM recruitment practice really designed to deter U.S. workers from applying, from even knowing the position exists? Some of the key highlights that really came out, and I think one of the ones that maybe rubbed the agency the wrong way and led to them digging a little further, is a requirement that the candidates who are responding to these PERM postings submit their resumes in hard copy. I used to do that as well 15, 20 years ago. It's not so much the normal practice. And then also where the positions are posted ultimately, which, again, letter of the law, both companies follow the rules and the regulations and From the Department of Labor perspective, when you're just looking at, did I follow the regulations? They checked off all the boxes. There's nothing that says you have to do it any differently. So what was different? Why was it really kind of highlighted? We can go to the next slide. We can talk about how the two settlements were a little bit different, even though the call outs in the way that the recruitment was conducted were very similar. Applicants being asked to submit their applications in hard copy rather than electronically. The postings not going up on the company website, on the career sites, those types of things that are common practices and compliant with Department of Labor regulations. But how they differ, and which might also be significant, is that the 2021 settlement agreement actually involved both the Department of Justice and the Department of Labor. The Department of Labor, in fact, in the 2021 settlement, conducted an audit of all pending perm applications for that company. And the DOL settlement included requirements for the company to provide additional notice and recruitment to U.S. workers, and they subjected the company to additional ongoing audit. So a lot of direct involvement by the Department of Labor because of its take on whether or not the company was actually fully complying with the perm requirements and regulations. And then we pivot to the second settlement agreement. Again, while they overlapped in timing of when the investigations were conducted, this second settlement did not involve the Department of Labor. And when the Department of Justice settlement announcement came out and the facts behind it were released, we were all waiting for the other shoe to drop. Where's the DOL's part of this? Are they doing more? Is there more of an investigation going on? Well, we're now into March of 2024. We still haven't seen anything. We're not really expecting to see anything. But who knows? Sometimes these investigations continue for a longer period of time. But so it was interesting to see the fact that in both agencies were involved, while in the Department of Labor, which you would expect to be involved in the perm context, was definitely there in the first instance. But in the second instance, it was really just the Department of Justice. Now, the settlement agreement with the Department of Justice did include provisions requiring the company to conduct more extensive recruitment for all perm positions, including posting the jobs on the company external website, including ensuring that they are accepting resumes and applications electronically, just like they would in any other instance, and then allowing the perm job to actually be searchable through their tracking system. So all things to make the perm recruitment and test of the labor market mirror the actual standard forms of recruitment that are being conducted. And there's a lot of debate about whether or not that's required, because we're talking about the Department of Labor regulations and why companies have to do this versus the Department of Justice. Why are they involved is, the question, and it's really at the core of it. The Department of Justice just basically says, we don't care why you're posting this. If it's negatively impacting U.S. workers, and if there's an impact that is discriminatory as a result, that's what we're looking at. It doesn't matter what your reason is for posting it. That's why we're looking at it. And as we're looking at this, for me as a practitioner and as I'm advising clients, the question really becomes, well, what do we do now? What is the difference in these two stories mean that I should be looking at this differently, or that there's an opportunity for us to change how we're doing things, or should we kind of wait it out and see? Because the Department of Labor wasn't involved. They did have a problem, apparently, in the second instance with what the company was doing. We can go to the next slide. So is the difference in the story behind these two settlements really significant? At the core of it, both companies were they had perm practices that complied and were following with the letter of the law. They checked off all those boxes. In the DOL context, the question becomes, did they comply with the spirit of the law? That, is that different between the two scenarios? Did they meet the good faith requirement that is actually in the regulatory requirements for perm? So you have your very specific letters or lists of where you have to recruit, when you have to recruit, what's the language you have to use in your recruitment, and we all follow that. We may ensure that we're compliant with those criteria. But then there's a line in there in the regulations about making sure that you are conducting good faith recruitment. So I think it goes in both scenarios. That's the underlying current as well. If you are asking applicants to submit applications in hard copy rather than electronically, when for years you have been accepting electronic applications, does that change whether or not a determination can be made that your practices are actually in good faith? If you're limiting where you're posting, is that really in good faith? So those are the questions that come up, and I think from my perspective, why in particular the Department of Justice was also so very involved and found it egregious in terms of how the recruitment was being conducted. So the DOJ is really looking at that in particular. And as I mentioned, the artificial nature of whether or not a position is actually open is not something they care about. When we talk about the perm process, I often will refer to it as a test of the labor market. I know a lot of people say recruitment because that's the shorthand, that's what everybody understands, but ultimately it's not really recruitment, it's a test of the market. You already have a position filled, you don't actually have an open position. And when you try to kind of address that with the Department of Justice, it seems that the response is it doesn't matter. You're still posting the job. It still comes under the purview of whether or not it's discriminatory in the way that it's being applied and used, regardless of whether or not you deem it to be an artificial process, since the position is actually already filled. And for me, over and over consistently, what comes out that this really highlights the flaw of the PERM program at its core. The recruitment versus the test of the labor market model. For those of you who might remember, before PERM, there was reduction in recruitment, RIR, labor certifications were filed with the Department of Labor. It was before the regulations delineated where to post, how to post, what language to include. And in fact, we were actually able to utilize real world recruitment. We used to be able to capture the ads that you posted, the recruitment that you conducted, the applicants that you reviewed in the 6-month period. The 180 days has always been 180 days, but we used to be able to actually relate back to the recruitment you'd already conducted. So if you had already spent 3 months hiring or looking for someone to hire them, and you had posted your job, and you had a bunch of applicants you went through, and you could document why they didn't qualify, we could actually leverage that. It made sense. It was more aligned with real practices. What happened when the PERM program went into effect and these regulations were implemented that dictated how you post your jobs, dictated how you conduct this test of the market, we had to create this alternative way of conducting this that no longer mirrored your real world practices. And that's the disconnect. I think both the Department of Justice and the Department of Labor have not yet really acknowledged that the reason companies are having this problem, that the reason companies seem to be creating this artificial process that doesn't mirror their real world practices is because the PERM regulations are pushing us to. We don't really have a choice. How many companies actually post their jobs in a Sunday print ad? I always ask that question, and yet that is still what we are doing. Look, at the end of the day, unless we can have a way and a conversation with these agencies that helps them understand and see that it is the regulations that are have shifted this to such an extent that it's no longer mirroring the real world, I don't know that we have a resolution, and it's going to be more and more difficult for companies to be able to comply with both what the Department of Justice is expecting and what the PERM program is expecting. And I'm going to flip this to you, Leon, because I'm curious of your thoughts on what advocacy can look like, especially in light of, at least under the current administration's efforts, of really pushing the boundaries of being able to leverage immigration to support our efforts in AI and technology and the executive order that is more recent.
Well, I think in those 2 letters you said a moment ago, I think is part of the wedge for this administration to really dig into this issue, which is the administration a few months back issued an executive order, really generally styled as the administration's effort to consolidate the United States as a leader in the emerging artificial intelligence world. Some of it included regulatory and integrity measures, but some of it also really spoke to using or designing the immigration system in such a way as to really favor immigration of those who really will help bring about U.S. preeminence in the AI world. Now, an executive order is not exactly a law, so there's a long road between that and the law. And so, you know, the question is, what are the pathways to getting that to change? One of the things that always strikes me whenever I hear this conversation was that when these systems were designed, the kinds of visa backlogs that we see now, where people are waiting 10, 15 years to get their green cards from the time that their petitions were first filed, is totally different, because in the beginning the petition would be filed, the position would be completed, and the person would walk right into the position. So there wasn't really, these sort of long lags before an individual. So the labor market when an I-140 is filed or when a perm is done to when the person actually enters the job are two completely different labor markets. It is, as you say, completely artificial and fictional. So where are the points of adequacy? I mean, I would say Capitol Hill. The problem with Capitol Hill is that they have shown themselves over decades now to be totally ineffectual to bring about any kind of meaningful immigration legislation, regardless of whether you favor comprehensive immigration reform, whether you favor on just business immigration. The bottom line is that there has not been a sufficient majority in both houses of Congress to move anything forward. So that really takes us back to where we are with the executive branch. And I really see two pathways here. Pathway number one is the two settlements that you talked about are just that. They are settlements. They do not represent, they only represent the acquiescence of two companies to the Department of Justice's view of the law. They don't create the law. And so, we're still in a place where there is some room where litigation could potentially move the needle one way or the other. In other words, make clear that these settlements actually do represent the law of the court, or that in fact what the Department of Justice is doing is arrogating what should be the responsibility of the Department of Labor, which takes us about 6 blocks down the street, 1 block over to 3rd and C in Washington, D.C., to the Department of Labor. And I think your point is correct. I think real advocacy with them, for them to take responsibility for designing through their regulations a realistic labor market test, both in terms of really representing the market and two, really not starving companies of the talent they need, especially in areas that are priorities for the administration. And so I think that's where the dialogue needs to go. I think industry organizations need to be part of that dialogue. Your employers, for many of you who are on this call, have a lot to say about this as well, because it's really their needs that we're talking about. So I think that's the pathway. I think it's going to take a while to get there. But I think these cases are perhaps turning this need into an emergent one, especially in the manner in which it is intention with, for example, the administration's interest in really pushing forward the U.S.'s position in the artificial intelligence world. I want to. Yeah.
Sorry, it's just, I'm going to close this slide out with just a call, get fired up and inspired is my point, because this impacts you, right? And I think there are ways to advocate for what your business needs through U.S. chambers, through other coalitions, or directly, that maybe it's not litigation. I know most companies are not inclined to go forward that route, and I don't think that's the answer, honestly. I really do think it's advocacy at the Department of Labor level. to make this more realistic. There is a model in place. I referenced the higher education model because that one actually takes into consideration, and they don't have to go out and do another random round of recruitment. That's not realistic. They look at what they've already done. And that takes us to the next slide where, okay, so we're here now. We have these two settlements. We have these two concerns that are out there and everybody's talking about. Do I have to change how I'm doing this? What is this going to mean? What are my alternatives? So these are some alternatives to look at and consider in terms of trying to bypass the PERM program where you can. This doesn't fit every company's model based on the population of your workforce and where they sit. But we're right now for it anyway, for the rest of this year, for this administration, there is a trend that they are very much amenable to approving these types of petitions for extraordinary ability, for example, right? These are immigrant visa petitions for those who are really at the top of their field. We are seeing more expansive application of what qualifies, which is really fantastic. Historically, it hasn't been there. It's still not easy. It's still challenging. We still will get requests for evidence, but still an avenue that maybe this is a time to be a little bit more aggressive for your top people. And maybe this might work. And if not the first preference category of extraordinary ability, because it is such a higher standard, look at the second preference category and these national interest waivers. This one actually is one of the most surprising. Historically, most of us stayed away from it. When we did file them, the standard seemed too high. It almost was as bad as the EB1, so people kind of just stayed away from it. But in the last couple of years, again, with the current trends, with the current administration, there is this more expansive look. And the key part to this national interest waiver versus the EB1 category is that it's not always about what have you already done. It's about what you could do for us, right? What you could contribute based on what your credentials are, where you're at in terms of the company you're working with, what you bring to infrastructure, to national security, to the US, it's all sorts of things. And I encourage everybody to really be expansive in your view of what could potentially qualify. Think back to all the issues we had throughout COVID and now post-pandemic, right? All the key things that impacted the ability of our economy to continue and to rebound. Think about supply chain. Those are critical. At the core of this, the NIW is really about anything you can tie to infrastructure, anything you can tie to the importance of on a national scale, that this individual that is with your organization, that's important to your organization, is actually important to us all. You should really look at and consider this national interest waiver concept, because it is there, it is available right now. And for as long as these adjudication trends continue, while we have these PERM issues on the other side of it, definitely something to consider, definitely something to talk through and strategize, with your leadership and with your outside counsel. Leon and Shelley, I don't know if you guys also have any other thoughts here as it relates to kind of these other arguments outside of the PERM world.
Yeah, I mean, I certainly want to talk about how this is manifesting in the H-1B, and we actually got a H-1B world because we did get a question about that. As a general proposition, the Department of Justice has had an interest in this going across, both Democratic and Republican administrations, to focus on discrimination in favor of sponsored foreign workers versus U.S. workers. And this is something we actually do see quite a bit of in the lesser skilled categories. There are a number of cases in the H-2A and H-2B categories where these kinds of allegations are made and where they stick. There has also been an interest in making those same kinds of cases, similar to the two that Masa was talking about in the PERM context a few slides ago, in the H-1B context. And in fact, there are advocacy organizations that are seeking to recruit plaintiffs to claim that they were either denied a promotion, denied a position, were unaware of a potential position, all because of some perceived favoritism on the part of companies in favor of H-1B. Now, what this disregards is what many of you in this call well know, is sponsored workers cost money. They cost filing fees, they cost legal fees, and in reality, the way that the wage setting system works, they make at least as much as their U.S. worker counterparts. It's what the law requires, and it's what the Department of Labor very actively scrutinizes on the part of companies. Nonetheless, and I'll ask that we go to the last slide in our deck. Nonetheless, there have been a number of cases filed with the Department of Justice Immigrant and Employee Rights Section, usually by single individuals, although we're now starting to see some mass filed through these advocacy groups that we talked about, filed by individuals alleging that they either were not hired because an H-1B got the position, or they believe an H-1B got the position that they should have gotten, or they were denied some internal reassignment that they desired because an H-1B was hired into that position. And so next slide, please. Oh, I'm sorry, back one. I'm looking. And so generally, these cases do not succeed. We handle a lot of them here in our firm. Generally, they do not succeed because the plaintiffs are not able to demonstrate that, in fact, the company had a preference for H-1Bs, and usually employers are able to demonstrate an appropriate business rationale for the decisions that they made. But nonetheless, on the way there, companies will have ended up spending a lot of resources pulling together documents, providing for interviews with the government, paying lawyers' fees, of course. And in a lot of these cases, after the Department of Justice has concluded its investigation and decided that they don't want to proceed, the individuals are able to file before an internal Department of Justice tribunal known as the Office of the Chief Administrative Hearing Officer, and pursue these cases on their own. And those in turn can turn into fairly protracted litigation. And so companies should think about, as when they do have positions for which both H-1Bs and U.S. workers might be eligible, they may think they want to be thoughtful about what they do and say throughout the hiring process that may or may not result in the selection of an H-1B. First, H-1B, they should actually have contracts on file for their H-1B. One pitfall we've seen in some of these cases is that companies, for various reasons, didn't have contracts on file, making it harder to prove that the company, in fact, had an extended commitment to that particular individual. We've seen this, for example, in the academic world. Also, and you do need to do some education, not just of your HR folks and your talent development folks, but your supervisors who might be supervising an individual who might be supervising the job that an individual was seeking, to avoid making statements to a worker who was either denied a transfer, not selected for hire, that the reason that was done is because the company felt that they were obligated to offer that job to an H-1B beneficiary. That's never actually the reason. And managers should be cautioned not to offer that rationale as the reason why somebody was not selected for a position. It's also important to debunk something often heard from these types of complainants and those who advocate on their behalf, and that is U.S. workers are not entitled to a preference over H-1B beneficiaries. Unlike the perm context that Masa was discussing, where there is some notion that if there is an available U.S. worker for that position, the U.S. worker must take primacy. That is not true in the H-1B context. The only obligation there is to not discriminate against U.S. workers and to pay, whether it's the H-1B or the U.S. worker, to pay the prevailing wage. There is no actual preference found in law for H-1Bs. So again, this is not an area where you're going to find a lot of companies actually found liable. But on the way to not being found liable, there's a lot of pain, and therefore some caution ahead of time is worthwhile. With that, we are at the top of the hour. I think we do have a couple more questions that we've not been able to get to. And we will make sure to respond to those questions in writing after the webinar. And with that, I want to thank Masa and Shelley and all of you for joining me this afternoon. Masa and Shelley, I'll present with you anytime.
Thank you. It's been great.
Really great to hear what you both had to say. And with that, I'll wish everybody a great afternoon.
Bye, everyone. Thank you.
Bye.